May it please the Court. Michael Lufferman on behalf of the Appellant William Patrick Russell. Seated with me at counsel table is Robert Harrison, who was trial counsel in this case. I'd like to reserve 5 minutes of my time for rebuttal. I'm hoping to focus my time this morning on the first and second claims raised in the briefs, and if the Court has any questions about the third claim, of course I'll address those questions. The first and second claims are interrelated, and I think the issue for both claims is there any evidence in this case, absent my client's statements, that the driver of the fourth vehicle, the gray car, was impaired at the time of the accident? There's no question that there's evidence of leaving the scene of an accident. My client's statements are not necessary to establish that. My client's serving time for that conviction. That's not being challenged on appeal. What is being challenged is the DUI manslaughter conviction. The judge in this case, notably, actually sent an email to the parties after hearing argument and considering this for a number of weeks and said, I'm going to grant the motion to suppress based on the Corpus Delicti doctrine. But then the judge did a 180 and reversed course and said, actually, I'm looking at the Walton case, and I think the Walton case requires me to deny the motion to suppress. As I've argued in my briefs, when one reviews the Walton case, not only does it refute the judge's analysis, it actually supports my client's argument that Corpus Delicti applies in this case. And the reason for that is at the end of the Walton opinion, this court specifically said that the holding in Essler was correct. And in Essler, the state was not able to establish, absent the defendant's statements, that the driver of that vehicle was intoxicated at the time of the accident. Essler involved a victim in a wheelchair who was hit, and then the driver of the white car who hit the victim in the wheelchair drove away. This court affirmed the leaving the scene of an accident, just like in my client's case, but the court reversed the DUI with injury count because the court said, absent the defendant's statements, the state in that case could not establish that the driver of that white car at the time that the victim was hit was intoxicated.
So your point, though, just to follow through, is the retrograde extrapolation cannot occur without the defendant's statement of when he drank last.
That's exactly right.
Without that statement, you can't do that calculation.
I think there's a close issue about who was driving, but no question putting the driver's side of it, the intoxication element clearly cannot be established without my client's statements. Gina Connolly, who is the state's FDLE expert, this is pages 684 and 685, specifically said that she could not do a retrograde extrapolation analysis unless she knew that the person in question had not consumed alcohol in the 1 hour before the accident.
And in this case, if I recall, he says he stopped drinking at 2.
His statements established that, correct.
So that's the only statement we have about that he was drinking and when he stopped.
And the state, to their credit, on page 15 of their answer brief specifically says, thirdly, you need to know the time of the last consumption of alcoholic beverages.
And the accident occurred at 9-ish?
A little before 10.
A little before
9:53.
So her statement is you need to know if you drank in the hour before.
Correct.
Okay, so and clearly his statement would indicate that's not the case. All right.
His statement would, but nothing else would
Right,
establish that.
That's all you got.
So,
Yeah.
because we know, just to follow up on that a little bit, and Your Honor obviously knows these facts based on your questions, but the blood alcohol draw in this case was at 1:13 p.m. It came out as 0.071 or 0.072. The state, again, to their credit, specifically states in the answer brief, this is page 14, that Sergeant O'Donnell, who responded to the apartment complex where my client lived, did not notice any odor of an alcoholic beverage on appellant. There was no balance issue or stumbling or slurring of words. There were no factors classically associated with a DUI.
Now, there were no, even though this was a college party, there were no witnesses called that said he was at the party and drinking.
Correct. Only his statements established that he may have been drinking at the party.
So surprisingly, even though there was a whole house full of kids drinking, none of them were called as witnesses and say, hey, he was at the party and we saw him drinking.
Correct.
Okay.
So all we know is that he said that he stopped drinking at 2 p.m. Absent that, we don't even know that he was drinking at the party. We certainly don't know anything in that critical hour before. And then I've cited to the Haas case, and in Haas, the Florida Supreme Court specifically said that test results shall be prima facie evidence that the accused had the same blood alcohol level at the time the vehicle was operated. So if you look at his blood alcohol level as 0.071, 0.072 at approximately 115 under Haas, that's the same blood alcohol level he would have had at the time of the accident, 953. Prima facie, we all know, is defined as legally sufficient to establish unless it's disproved. The only way the state could possibly disprove that his blood alcohol level was 0.072 would be to do a retrograde analysis. They cannot do the retrograde analysis if they don't know whether he was drinking in that 1 hour before the accident. They can only get that information based on his statements. And
Now,
when
to establish corpus delicti, the burden is quite a bit lower.
It is.
So was there not testimony other than his inculpatory statements to indicate that this was a BYOB, bring your own beer party, that it was a drinking party that he had attended, and that there was a flop house
Yes.
where people who had been drinking normally went to flop, I don't know if that was the term used in the testimony, but
Yes.
And why does that not give rise to corpus delicti to say that, well, there was an accident, there was paint transference, this was the car, that's a reasonable inference.
Yes.
That's evidence of the car. The video, at least, is suggestive that the gray car, well, we can leave that aside whether the video suggests that it was erratic or carelessly driven. But the simple fact that the individual, that the sheriff's deputy or the police officer met in the parking lot, who owned the car, had been at a drinking party, why is that not enough to establish corpus delicti to admit his statements?
A drinking party the night before, that there's no evidence that he was drinking at. So I would argue, even if there was evidence that he was drinking at 11 o'clock the night before, that's not going to show that at,
Impairment.
10:30, 11 o'clock the following morning that he's impaired. But when you add in the fact that there's no evidence.
We're not even trying to survive a JOA here. We're
Sure.
just trying to have enough evidence so that there is some, this is a little too speculative, but a specter of the type of harm to the victim and criminal agency.
So this is from the AP case. That's the most recent case from this court that talked about corpus delicti. Substantial evidence tending to show the commission of the crime charge and all the elements does not need to be uncontradicted or even overwhelming, but there still must be substantial evidence. There's no substantial evidence that at 9:53 my client was impaired or intoxicated. None. There's not even substantial evidence that the driver of the fourth vehicle, whoever that driver might be, was impaired or intoxicated. What we know from the Haas case is it has to be presumed, and it can't be disproven because all they have is retrograde, that my client's blood alcohol level would be 0.072 at the time of the accident. If this case went to with state rested and the evidence only showed that my client was driving a vehicle with a blood alcohol level of 0.072 and there were no signs of impairment, which the state, again, to their credit, specifically concedes in their answer brief, that as a matter of law, 0.072, my client cannot be guilty of DUI manslaughter. Cannot be. 0.072, the other thing the state conceded in their answer brief is a driver in Florida is considered impaired at 0.08. That's on page 2 of its answer brief. 0.072 is below that. That's the presumption of what his blood alcohol level would have been at the time of the accident. They have nothing to refute that. Nothing. They can't. The only thing they can rely on, and that's the other thing, the state, I would say this, they skirt over this issue. I've cited the Haas. Haas is not mentioned in the state's answer brief, and the judge kind of skirted over this as well when it was brought up to him that, oh, there's a second motion here dealing with retrograde and corpus delicti, and the judge said, oh, I've already ruled on that, and then when he realized that he hadn't, he just issued an order that said, I've already addressed that in my previous order. Well, the judge doesn't address that in his previous order. The judge's order simply says, the state asserts that retrograde will provide a blood alcohol concentration of 0.08. And then the judge concludes at the end of the order, this is 187 to 190, that the defendant had a blood alcohol concentration of 0.08 or more at the time of the offense. There's nothing establishing that other than the retrograde. But if the retrograde can only be done based on my client's statements, there's nothing in this case that shows that my client was over the legal limit or intoxicated or impaired at the time of the accident. In fact, it's just the opposite. The presumption is that he's 0.072. We know 0.072 is not enough. The state concedes that when Sergeant O'Donnell arrived at the scene, he specifically did not see any signs of impairment. And when you add those together, and it is a little bit of a math puzzle, but when you connect those dots, the result is my client's convicted of leaving the scene. Essler requires that, but my client is not convicted of DUI manslaughter. There's no independent evidence other than my client's statements to in any way establish impairment or intoxication.
Let me ask you a question. Hodges versus State, Supreme Court decision in 1965, basically stands for the proposition that although the corpus delicti may not be established only through a defendant's statements, nevertheless, confessions and admissions may be considered in connection with other evidence to establish it.
Sure, and the state cited that in their answer brief. You can consider it in connection, but at the end of the day, if my client's statement is the only thing that would establish the element, then that's not enough, and that's what corpus delicti stands for. In this case, the only way to get to the intoxication element is my client's statement. You cannot get there absent and Ms. Conaway specifically said it's critical. That was her exact word, or she agreed that it's critical. If you don't know what whether he had anything to drink in the hour prior to the accident, she cannot do retrograde. And absent retrograde, they cannot reach intoxication in this case.
Justice Shaw, concurring in Burks versus State, Supreme Court decision in 1993, basically says, in cases where the physical corpus is difficult to determine or difficult to separate from a confession, the court should essentially look at the trustworthiness of the confession.
I agree, Justice Shaw. He's going a little bit in a different direction. That's certainly not the direction that, and that's a concurrence, and that's the reason why. That's not the majority, that's not the law in Florida right now. The law in Florida is there substantial evidence of the elements? And if there's not substantial evidence of the elements, then corpus delicti applies, and you must exclude the statements, and if whatever's left doesn't amount to a crime, you don't have a crime. And again, I come back to Essler. You could apply that reasoning in Essler. In Essler, when the defendant in that case was found in Polk County, if I remember correctly, it was sometime later in the afternoon, she was extremely intoxicated. They brought her back to the site of the Hillsborough accident where the man in the wheelchair was hit. And
there's a different problem there. You wouldn't disagree that the person encountered in the parking lot by a law enforcement officer, there was evidence that he was driving the car that impacted the cars involved in the accident. That corpus delicti part, in other words, in that other case...
In Essler?
Yeah, in Essler, there was difficulty. They couldn't establish corpus delicti because they couldn't establish that she was driving the car that struck the victim.
No, I think that's exactly what Walton said Essler does not stand for. I think the analysis, and it starts with Colorado, and obviously, Your Honor, you're familiar with that, you were the author of that opinion. You have these circumstances where sometimes you have the victim and the defendant in the same vehicle, and we don't know who's driving, and in that situation, did he have to prove who's driving? And in Colorado, the evidence was clear-cut that they were both intoxicated, the victim's dead, and the result is you can't be guilty of DUI manslaughter if you're the one that's driving and you kill yourself. So there's no evidence of a crime at all, and that's why corpus delicti applied in that case. And so Walton went through this and tried to answer this question, do you always have to show who the driver is in one of these cases? And the conclusion is sometimes you do, like Colorado, and sometimes you don't, like Walton. Walton, you have 3 people in the truck. The evidence is crystal clear that they're all...
You said, but in Essler, correct me if I'm wrong, I'll just ask you to correct me if I'm wrong, they could not connect her car to the wheelchair.
No, I disagree with that. I think what Walton did was clarify that the reason that Essler is correct is because in Essler they couldn't show that she was intoxicated at the time she was driving. And that's exactly what we have here. I think the court in Walton went out of its way to say Essler does not stand for the proposition that you always need to show that a particular defendant is a driver in order to have the evidence.
That's because it was distinguishing this scenario from cases in which the only folks involved were in the same vehicle.
But Essler is not that.
I know.
So I think I think the clarification in Walton is that Essler involved a single driver, or only one occupant of the car that committed the crime, and the question is how could they possibly establish that that driver was intoxicated at the time of the accident? And this court in Walton said that's why Essler is the correct result, because they couldn't make that link that the driver was intoxicated at the time. That's exactly what we have here. The state cannot make the link that whoever the driver of the 4th vehicle was, it could be someone else. The video doesn't show that it's my client.
But there's enough evidence to show it was him.
There's enough evidence to show that it was his car.
Let's say he was drunk. Let's say he showed up, and we had some proof that he was drinking.
It'd be a closer case about whether he was the driver.
Right. But for corpus delicti, I'm sure you would still be sitting here arguing that we don't know that it was his car.
No, I wouldn't be saying we don't know that it was his car. I want to be clear about this. I wouldn't be saying we don't know that it was his car. I think the damage to the car, the yellow paint, the video establishes that it's that gray car. But here's the key about that is We don't know anything about what time he left, who he was with, whether he was even driving. We don't even know the circumstances about him leaving the Lido Lane house at all. So, in the video, this is the other key part, the video doesn't show who it is or how many people were in the car. So, if it was clear that if Sergeant O'Donnell's observations were that he was stumbling, bloodshot eyes, smell of alcohol, there would still be an argument in this case that they can't show that he was the driver because there's not evidence excluding someone else. And again, he was coming out of the apartment. We don't know who else may have been in the apartment. So that's a closer case. And I'd still be arguing that. Not that it wasn't the car, but that he wasn't the driver. But the bigger issue here is that we clearly don't have his intoxication. Absent his statement, you can't do the retrograde. Absent the retrograde.
Because time is short, I wanted to ask you one other question.
Yes.
There's an assumption, there's a presumption that the blood alcohol level at the time it was taken is the same at the time of the accident.
Yes.
Does that, in the context of Corpus Delicti, which I perceive to be a lower burden of evidence, does that preclude the judge, who has to determine whether the Corpus Delicti exists, from making what some might say is a common sense assumption that you're absent any other circumstances about whether any more drinks were consumed between the time of the accident and the time of the blood draw, that the blood alcohol level would be greater in the past?
Yes. Two answers to two parts of that. I don't know where I am in my rebuttal time, but
Well, Judge Atkinson has gone over your time, but I'll let you still have it.
Thank you, Your Honor, and of course you're allowed to do that.
I know.
My two answers would be this. Number one, I gave you the definition of prima facie, but I want to repeat it. The Merriam-Webster, the Black's Law Dictionary of prima facie, legally sufficient to establish a fact unless disproven. So under Haas, his .072 is prima facie that his blood alcohol level is .072 at the time of the accident unless disproven. So the state would have to disprove it, number one. Number two, to go back to your question, I submit it's just as likely one way or the other. We don't know if he's in the absorption phase or the elimination phase. There's no way to know that he may have had a drink or may not have had a drink. It's possible he had a drink at 9 o'clock. It's possible he didn't have a drink. I don't think there's any assumption that could be made, and that's exactly why Ms. Connolly said what she said. If going back to that question then, she could have said, actually, I think as analysts we can assume that knowing the circumstances, the time of morning, that someone would not have had a drink, and therefore I would still do the retrograde. That's not what she said. She said, I need to know. The exact word was critical. If I don't, and the state concedes that, if I don't know whether he consumed in that previous hour, I cannot do retrograde. The only way they know that is his statements. I'll reserve the rest of my time for rebuttal.
Thank you.
Thank you.
May it please the court. I'm John Salgado, representing the state of Florida in this matter, Patrick Russell.
You know, it'd be really helpful if you just right now walk us through the elements of the corpus that the state had.
Sure.
I know you briefed that carefully, but I got to be candid with you. I'm not persuaded, so I'm going to give you a chance to persuade me.
Okay. Was he impaired at the time of the accident? We talk about substantial evidence with corpus delicti, but substantial evidence also includes circumstantial evidence, and that's what we have here. We have circumstantial evidence. We have a young man that went to a social event where it was BYOB, where there was drinking. We have Sergeant O'Donnell, 30 minutes after the phone call, after the accident, when Mr. Russell called, Sergeant O'Donnell goes to his apartment complex. In his deposition, he says he was sluggish, he didn't smell of alcohol, however, he sensed signs of impairment. It's our position that if you take this evidence, the aggregate of this totality, that's enough, because I believe we had mentioned the burden involved with corpus delicti, that it doesn't have to be overwhelming, doesn't have to be contradicted.
So an hour after the accident, this officer meets him in his parking lot, and he does not have any odor of alcohol about him, doesn't have any slurred speech, glassy eyes, he's not wobbling. As best I understand this officer's testimony, but he sensed that he was impaired. Can you drill down on that for me a little bit?
I did not have the depth to see that, but again, if you take that, that's just a bit of evidence. Again, if we take that with all the other, I mean, in his experience, the fact that he sensed some impairment, I think there's some validity there.
Where in the record does it say that, do you know?
It says it, I believe it's something that the parties agreed to, actually. Both parties agreed that in his deposition, he had sensed some impairment. Indicators, as it's put, indicators of impairment. Now, some case law was mentioned, Walton, where the court noted where it seemed like it was going to allow for the motions to suppress, but then it looked at Walton, and Walton goes into the history of Corpus Delicti. It mentions, I think, the classic Allen, State v. Allen, where it talks about the burden not being overwhelming, not being uncontradicted. It talked about Burks, I think that was mentioned also. That also kind of reaffirms the Allen case. The state provided independent circumstantial proof that he, let me emphasize that he was the sole driver to connect that piece. I think we went over that, the video camera, the yellow paint transference on.
Can I stop you for a minute?
Sure,
Just
certainly.
to go back. So he, the Sergeant O'Donnell said he was kind of sluggish. Is that what
That's
you're
correct.
referring to? Like he may have been under the influence of something, either drugs or alcohol.
That was in the joint stipulation.
That's
That
correct.
was stipulated that was deposition testimony.
That's correct. I
Can you
actually
confirm?
believe that helps us, because that sort of shows that he had nothing to drink after the accident. So I think that actually helps us, that there was no sense of odor, because I think it was mentioned also that it's possible that he could have had a drink after the accident. But it's highly unlikely, and again, from that deposition, he did not, which
Well, it
adds
sounds
more-
like the state, my perception is threading a needle hill or walking a tightrope or on the horns of a dilemma, whichever metaphor applies, that he had there were not enough signs of impairment to suggest that he had another drink, which would undermine the state's case. But there was enough signs of impairment to say to get you the corpus delicti if you wanted to dispense with the retrograde analysis.
That's correct.
So it sounds like a horns of a dilemma for the state.
Well, if I can kind of switch gears, and I don't know if I completely answered your question, Judge Morris, on corpus delicti, the meeting the elements of DUI manslaughter, that he was the person in the vehicle. The vehicle was solely registered to him. There was no evidence introduced that it could have been his partner, his children, or, well, he was actually a young man, but anyone else. So I don't think I think we can agree that that was his vehicle. He was in the vehicle at the time of the accident, meeting that element of the DUI manslaughter. So again, it kind of goes back to what counsel said, that was he impaired at the time of the accident, and it's our position that based on the evidence as a whole, that if you take that in the aggregate, that you can introduce that, and that is enough to bring in his admission that he was drinking and that he was at the accident scene. I believe that in issue 2, it's our position that defense attempts to conflate the corpus of DUI retrograde extrapolation analysis to stop the state from introducing evidence of the admissions by defendant as to when he last consumed alcohol. They're separate. These are separate. When the state established corpus delicti, which that's our position that they did.
Well, that's an interesting point. So you're saying are you saying what you just said, they did not need, that to establish corpus delicti, the state did not need the statement from the defendant that he hadn't had a drink since 2 in the morning? Or are you saying that that is not an inculpatory statement that is prohibited by the requirement?
That's correct, that they're
of
separate.
corpus delicti?
And even I'll go as far as to say, do we really need the extrapolation? I mean, the element of being, not having your normal faculties could actually be a 0.7, could be a 0.6, doesn't necessarily, if you look at that element, it's or .08 or more. So with regard to the third, because all of these motions to suppress, there were 3 of them, and they were all denied. Regarding the issue 3, the experts and their credibility, whether it's extrapolation is respected in the scientific community, it's our position that that's something, and it says it in the order, that's something that goes to the weight of the evidence, not the admissibility. And again, this never got that far. I mean, it was settled.
Can I go back to the question? So,
Yes.
I wanted to pin you down on a
Yes.
couple questions. Maybe it's neither, maybe it's both. But starting with this one, is the statement regarding when the defendant took his last drink an inculpatory statement, or is it the type of admission that, for admission into evidence, requires a corpus delicti?
They're separate. I mean, I don't know if I'm understanding, if you...
The next question would be, is if you were not able to consider, if the judge was not able to consider it in determining corpus delicti, is it necessary? And the defense has argued it is necessary because in order to prove impairment, you need the retrograde analysis, and to do so, the state's witness said unequivocally, I need to know when he stopped drinking.
It's not necessary. Again, when you take all of the evidence, when you take the fact that he was at an event, at the social event the night before, the fact that he left the scene of the accident itself doesn't show rational, good thinking. The police officer's deposition, if you take all of that, all you need is just some evidence to be substantial, and that can be circumstantial. I don't know if I answered that correctly, completely for you, Your Honor, but that is our position. Just to clear up something on the point that he made regarding Essler, and Walton does talk about you take each case for its own merit, and Essler, the big difference there was no physical evidence involved in the Essler case, where in our case, again, we know that it was his vehicle, we have video, we have paint transference on his headlight, so there's a clear distinction there. Unless the court has any further questions, the state asks for relief that the conviction and sentence be affirmed in this matter.
Thank you, Mr. Salgado.
May it please the court, I'm hoping to spend my rebuttal time responding just to this idea regarding Sergeant O'Donnell.
So before you do, can I just summarize it a little bit? I don't want to take any more of your time than necessary, but all the state has is that officer shows up an hour after the accident, meets the defendant in the parking lot. He doesn't exhibit signs of impairment, but based on the officer's experience, he feels like he is. That's what I heard. I wasn't there. I only know what I read and what I heard. And that he sees a car meeting the description of the car that was in the accident with the paint transfer. Isn't that enough?
No, but I want to be clear about what Sergeant O'Donnell said, and there's no doubt about this. It's in pages 166 through 173.
It's not enough to prove the case, but is it enough to use now the statements?
For impairment, no, and here's why. Sergeant O'Donnell said he appeared sluggish, and he, quote, may have been impaired, and didn't sense that he was wasted. I submit there's 2 reasons, and then a case I want to talk about, that's not enough. The first reason is the state didn't think that was enough, because the state, in its own answer brief on page 14, said, while Sergeant O'Donnell noticed that appellant seemed sluggish, he did not notice any odor of an alcoholic beverage on appellant. There was no balance issue or stumbling or slurring of words.
The state has the problem we don't necessarily have, which is they are trying to thread the needle. So they need him not to have smelled alcohol on his breath in order to say that he hadn't had a drink recently. But at the same time, they'd like to use Sergeant O'Donnell's statement to prove that there was the specter of impairment in order to get to corpus delicti. The trial court admitted the statement, and why isn't the statement from the officer? Well, I don't know that he was wasted, but I did sense there was something that was there that kind of showed some indicators of impairment. Why is that not meet the corpus delicti of
Because it's not enough for impairment. It's sluggish, it may have been. So number one, the state, I submit, when they wrote the answer brief, didn't think it was enough. The other key point I would make is the trial judge in no way relied upon that. The trial judge's only basis of impairment in this case is retrograde. The trial court's two different orders on this do not at all cite to Sergeant O'Donnell's, and I understand there's tipsy coachman, but nevertheless, that gives you some insight into the trial court's own mind. Judge Roberts didn't think that Sergeant O'Donnell got them over the finish line, or he would have cited to it. He, as far as impairment is concerned, only relied upon retrograde, not at all Sergeant O'Donnell, because I submit he has the same view that the state had when they wrote the answer brief. Simply saying that he's sluggish may have been some signs. That's not enough to show impairment. And then I want to compare that to Burks. Burks is one of the lead cases on this where the courts have said that there was enough. Burks is out of the Supreme Court of Florida. Here were the indicators in Burks. In the instant case, Burke's speech was slurred, his eyes were bloodshot, he smelled strongly of alcohol, and there was a dead body on the road. When you compare that...
Was that a Corpus Delicti case, or was that
yes, that is a Corpus Delicti case, and they said that there was enough for Corpus Delicti. Impairment was established based on those factors, and notably, those are the exact same factors that the state seems to be comparing it to in their answer brief to say that what Sergeant O'Donnell said is not enough. So I submit to this kind of new arguments to being presented, oral argument, that Sergeant O'Donnell is what got them over the finish line. That's not what Judge Roberts found. That's not what the state initially argued, and I think a fair reading of what Sergeant O'Donnell said in the stipulation is not enough to show impairment. It's the retrograde that they've been relying upon, and the only way they can get there is his statements, and that's why the DUI manslaughter should be
And
reversed.
that's clearly a statement that requires a Corpus Delicti.
Yes. Yes. So my response to that question is, I think the case law now is clear. Corpus Delicti is not just confessions, it's admissions. And that admission...
Admissions against your interest.
Yes, and that admission, A, that he had been drinking at the party at all and that his last drink was 2 o'clock, definitely is an admission that they're trying to use against him to establish this retrograde analysis as to whether or not he would have been intoxicated at the time of the accident. Absent that, they cannot get there, and because they can't get there, again, his conviction for leaving the scene is being affirmed. He just can't be convicted for DUI.
What would normally be an exculpatory statement, I stopped drinking at 2 a.m. here, is an inculpatory statement because it's being used by the FDLE agent to perform the retrograde analysis.
And then the only other thing, I think this court's aware of this, but he's also being convicted of the DUI with serious injury for the other 2 counts, and that's just because that's the nature of the plea agreement here. So the only thing we're challenging is DUI manslaughter. They do not have DUI manslaughter because they cannot establish impairment. I'd ask this court to reverse. Thank you.
Thank you, Mr. Appellant.